Good morning or good afternoon. My name is Florence Stainier. I'm a partner within the investment management practice of Arendt. I'm very pleased to welcome you today to the third webinar of our webinar series dedicated to UCITS. If we start with a little bit of number, we see that UCITS are still holding an important portion of assets under management in Luxembourg. And we also see that UCITS, when it goes about cross-border distribution, is certainly still the vehicle of choice, and especially when it goes about Luxembourg UCITS, since 54% of UCITS being distributed on a cross-border basis are from Luxembourg. So this shows how important UCITS are on one hand, and also the fact that dedicating some time to distribution is worth, especially in this time where raising of assets is key. And like we did over the past years in this series dedicated to UCITS, we wanted to focus on some legal and regulatory developments which were recently occurring in the distribution space. And one of the points we wanted to cover is certainly driven by these numbers, which shows that notwithstanding Brexit, UCITS distribution in the UK is still an important element since we see that United Kingdom is still a jurisdiction of choice for Luxembourg vehicle and more particularly for UCITS. So this is the reason why the first part of our webinar of today will be dedicated to recent development relating to the UK Overseas Fund regime. To cover this topic, I'm very pleased to be joined by Emma Garnham, who is a senior associate within the asset management practice of Macfarlanes in the UK. Emma is advising private funds, but also public funds, and she is more particularly focusing on registration, distribution matters, but also SFDR. Also with me, my colleague Alexandra Leininger, who is a director within Arendt Regulatory and Consulting, where she's part of the registration expert group, advising clients on the registration, but also on every kind of question which is related to distribution. On the second part of the webinar, we will cover other topics, among which impact of digital finance. And this is for that part that Pierre-Yves Mauchard, who is a senior associate within our investment management practice, will also lead the discussion. Pierre-Yves is also part of our expert group dedicated to digital finance and also a member of the ad hoc ALFI group on the same topic. So starting with the overseas fund regime, Alexandra, the question is for you. So we have seen that UK distribution is still a very important part for the UCITS. Also, it has been put, if I can say, a little bit on hold for a few years. So maybe you want to lead us with Emma on the recent development in that space. And before giving you the floor, I would like to mention to the audience that in case you would have any kind of question, please use the chat button and you will get any assistance from our market team.
Good morning, everyone. Effectively, the access to the UK market was a bit on hold, let's say, even though the temporary marketing permission regime was in place for funds that has already been notified for marketing in the past and have chosen to go for that TMPR. But for now, there are not so many easy solutions to access the UK retail market for new funds and even for umbrella structures that benefit from the TMPR but which would like to add like a new sub-fund for marketing in the UK. So there are Two solutions, I would say, still. There is that section 272 of the FSMA, but you probably know that this is quite costly and long process, more than 6 months to achieve somewhere, and sometimes it doesn't, it's not a success. And the second one is the regulation 59 of the IFM regulations. So as you can understand, it's like the implementation of the IFMD before Brexit, but still, let's say, applicable in case you want to sell to professional investors, institutional investors, and high net worth individuals. So definitely not the target market of the UCITS funds. So that's the issue, let's say.
And I suppose that if we have this webinar today, this is because we might see some light at the end of the tunnel, if I can say. So yeah. What are the developments?
Yeah, the developments is that very soon, the first one I would say is the extension of the TMPR, which is until the end of 2026. So that's a good news still. But more interestingly, I would say, there is the opening of the gates for the application of the overseas fund regime. So just to take a step back, back in January 2024, EU UCITS has been recognized equivalent to be in a position to apply to that overseas fund regime. So that's the big change. And the opening of the gate is as from September 2024 for the funds that are not benefiting from the TMPR. And then, once the gates will be open for those funds, there will be in October and in November the opening of the gates for the funds that benefit from the TMPR. That will be October for the standalone and November for the umbrella structure. The idea is that very soon there will be official communication from the FCA confirming the lending slots applicable.
And do you know management companies having already received these lending slots? How are you aware?
Actually, they have received the communication already, but that was not necessarily related to the lending slots. That was first in line with, do I want to maintain my registration? Mm-hmm. Do I want to continue market in the UK? And then very recently, we've seen that the FCA has published on its website the lending slots. So that will be by alphabetical orders. So you can easily find on the website where you would be supposed to actually apply for the OFR. But still, the FCA will send official communication to management companies just to make sure you understand the lending slot that will be applicable to you.
Still to be received.
Still to be received, exactly. And but that is effectively good news, but still you need to keep in mind that this is not like it was in the past. Mm-hmm. Marketing passport notification, easy, harmonized. That will be a substantive review from the FCA. So that will take time, and you need to anticipate and be ready for that. And Emma, maybe you can elaborate a bit on that, on the details of the application that need to be submitted and the time frame, because if I'm right, so far, and it was planned to be issued in July 2024, we don't have a lot of details from the FCA on the application itself.
That's exactly right, Alexandra. Thank you. So the FCA has consulted on what it expects to see in these applications, and they will be fulsome applications, but the final rules, as Alexandra mentioned, have not yet been finalised and issued. Those are expected very soon. The FCA expects to take up to 2 months to review each application. So bearing in mind you have a 3-month landing slot, you want to get in early. And the applications that the FCA will review being substantive, will include quite a detailed application form. They're proposing at least 30 different data fields at this stage, still to be confirmed, plus a full consideration of all of your fund documents. And something that's new that you won't have to have considered previously if you came in under the pre-Brexit UCITS passport is that you'll now have to advise on whether or not you have a UK authorised person who will be involved in approving something called financial promotion. So that's any marketing or communications material that you use in or into the United Kingdom. And we'll come on to that in a bit more detail a bit later on. So I think the short answer, Alexandra, is there's a bit of work still to be done, but we really need the FCA to publish those rules before we can get started on it.
But do you have an idea, Emma, if the marketing will be frozen during that period or during when the application will be submitted?
That's a really good question, thank you. So you will continue to have your TMPR marketing rights up to your OFR landing slot and all the way through to the end of your OFR landing slot. If you've not received your OFR approval by the end of the landing slot, then you will no longer have marketing rights until you receive the OFR approval. So I think, Alexandra, to your comment on timing, that makes it quite important to be ready at the beginning of that landing slot period.
Okay, so which means that definitely it will make sense to submit or to take care of everything at the very beginning of the landing slot, ideally within the first months. But what can we, let's say, advise or recommend to our clients, how they can be well prepared to make sure that they respect that landing slot? Because if I understand properly, at the end of that landing slot, they won't be in a position to market anymore.
That's right. So as you mentioned before, the FCA has already started contacting managers about this. Hopefully managers will, as a result of that initial contact, be checking the FCA register in the UK to make sure that your management company contact details are up to date and the list of schemes and sub-funds are all up to date. You can do that today. And the FCA just takes those updates by email. They're very welcoming of those, so please do check those. And then once the rules are published in July, so hopefully at the beginning of July rather than the end of July, you can then begin to prepare your application packs. We do expect a lot of the applications to be based on the consulted on proposals, which is in a consultation paper from last year. So you can prepare hopefully very shortly by ensuring your fund documents are up to date and ready to go, and you have an idea of what your distribution arrangements in the UK will look like.
You mentioned fund documentation, Emma. If I can ask one question, do we need already to advise our client that they would need to make any kind of additional information in the Luxembourg fund document, I would say? So do we need to expect a change in these fund documents?
That's another very good question. So the FCA has consulted on the need to include some additional disclosures. As you may know from marketing in the UK already, you may use a UK country supplement to your prospectus rather than amending your Luxembourg home documents. And we expect that same approach to capture any new requirements to be appropriate because, of course, we appreciate you don't want to be risking confusing any of your other home investors in any way.
Okay, so expecting a pragmatic view and no additional burden on the content of the Luxembourg document, which is probably good news. I would like also to ask you one question about the SDR requirements. I mean the sustainability disclosure requirements. I understand, but correct me if I'm wrong, that this would not be applicable to EU funds being marketed in the UK. Can I take the assumption that this will not be changing? Any view there?
So you're right. As at today, it doesn't apply, other than a small requirement for any UK distributors to ensure that there's a little note on UK marketing documents saying that these are overseas funds and not subject to the UK's SDR. But we do have coming later this year, it's penciled in for Q3, a consultation as to how the UK SDR might be applied to overseas funds. We don't quite know where that's going to land at this stage, or what the timing will be, so things will be clearer in Q3 on that. But as at today, you're out of scope of the UK SDR.
So, finger crossed that it will stay on that one. Maybe another question, speaking about distribution, that means that the EU UCITS ManCo will also definitely need to be ready for the gain. Does that, once again, opportunities for marketing UCITS to retail investor in the UK, but what about the marketing materials? As long as the UCITS has been approved for marketing for via passport, is there any kind of constraint there? Could you please comment on the impact on marketing communications?
Of course. So prior to Brexit, coming in under the UCITS passport, you had the marketing rights for the fund, and that covered all of your marketing communications. But the UK has a slightly unusual set of regimes that separate out your authorization or recognition rights for your funds and the documents for the funds and how you promote or communicate promotions about funds. That's called the financial promotions regime. And that's totally different to most of the rest of Europe. What that means in practice, and as I mentioned earlier, is that as well as getting the right to market your fund under OFR, you will also need to consider whether and how your communications to UK investors fall within the UK financial promotions regime. And it's quite a complex regime, but it's one that's very important to get right, because a breach of those rules is unfortunately a criminal offence. So what does that mean at a very high level? It means understanding your UK distribution chain. So who is speaking to who? What are they passing on? And the reason I ask those questions is that the exemptions from the prohibition on financial promotions, which is how this whole regime is framed, says that certain types of people can communicate certain types of documents, and therefore they are permitted to do so. So you'll see there's a little target diagram, hopefully, on your screen. And that's really just to illustrate that this regime is much, much broader than your standard fund marketing documents and what you might consider. That's to make sure that you're conscious of what you might be caught for. So I think at a very high level, think about who in the UK is speaking to your investors, who is approving the documents that are shared with investors, and from those two buckets, which financial promotions permissions or exemptions might apply to those, so that you're not in breach of the general UK rule.
Thank you very much. And if I can add one point, probably from a Luxembourg perspective, it means that the Luxembourg-based IFM would have one additional point of compliance to be taken into account. We know how much attention needs to be paid to the distribution network, to having knowledge as to the distributing parties, for many reasons, among which marketing communication, and this is probably an additional point of attention on the checklist, if I can say, to be taken into account. And Alexandra, maybe the good occasion for you to make the link with these expectation on the marketing communications.
Yeah, definitely. I understand that it's actually a huge review and a huge process compared to what was actually applicable before. But in addition to that layer, their IFMs in Luxembourg, or management companies in Luxembourg, have to comply with all the European requirements in terms of marketing communications, being the CBDF regulation and the ESMA guidelines. So you may remember that during one of the last webinars, we discussed about the CSSF campaign on marketing communications compliance check. and also the review internally of the approval and of the marketing communications. So since then, the findings have been published by the CSSF, and we have seen that there are some aspects that need to be considered. I will give you a few examples, which are the identification of the marketing communication as such, also the identification of the target market, which is very important because it really triggers additional obligations sometimes, and also, let's say, the disclosure of the costs, which was also a specific comment that the CSF has made, because even though you have to disclose, you don't have to disclose all the costs, but at least you need to say that there are additional costs that would be applicable. So those findings of the CSSF have alimented actually the ESMA final report that has been published by the end of May. So it's very, very recent. There are 27 national competent authorities that have participated to this exercise, with 208 clients or players that have actually been tested in terms of marketing communications, and also in terms of internal process to review the documents. So just to take a step back again on the objective of that report, that was really to ensure that there is no mis-selling of inappropriate products to non-experienced investors sometimes, and basically to protect the investors finally. So the outcome of the report was overall there was no aggressive, let's say, marketing or promotion of products throughout Europe. That was much more instead a fair and comprehensive marketing, and documents are clear enough, including necessary warnings, but still there are areas of improvements. And the ones that have been identified, the first one is the lack of alignment in the identification of the marketing communication. And one of the comments was it would be beneficial at least to have a definition of the marketing communication one day. Another one was in terms of the disclosure of the risks and benefits that were not sufficiently balanced. And another aspect, because that was not only the compliance review of the marketing communication, that was also an assessment of the internal review and the control. So it has been actually noted that there is lack of alignment between a firm to another on the control function and the internal review process of the documents. But since then, and especially I would say on the sustainability products, where it has led to like non-coherence with the fund documents or information that were outdated that was published. Since the findings, I would say, from the NCAs have been published, there have been remediation from the authorities through workshop, through individual discussions with the players. And actually this is supposed to be a recurrent work, because all these kind of reports will have to be done, let's say, regularly or every 2 years to the ESMA.
Thank you very much. And this is certainly the continuity to the webinar we had last year on the same topic, because one of the key topics was the ESMA guidance based on the CBDF, and we were expecting the result of the review from the CSSF, so happy to have that today and to be able to continue the conversation of the topic. As mentioned by Emma, this is certainly an area of to which some specific attention need to be paid, taking into account the responsibility and the liability that it can lead to, And we have seen many regulators, not yet the CSSF, I have to say, based on my latest information, having applied fines in this regard. And obviously we also expect some evolution maybe in that respect on the basis of the UCITS directive and AFM directive which have been adopted, where there are some additional explanation on the roles of the different bodies and the content of the marketing communication, but still we are going into the same direction. And as part of the greenwashing prevention, I would say, and all the actions from the regulator, this is also one way for them to pay their attention and to ensure that there is no misleading information, I suspect. So something on which we want to remain vigilant, and where your team more specifically can assist, since you are helping clients to review these documents, to make gap analysis and to ensure that they are aligned with regulation.
Exactly.
Emma, I wanted maybe to ask you a last point, which is deriving from our conversation, I would say. Obviously, since Brexit, there is unfortunately no so-called UCITS, UK UCITS as such. So we have seen that also, I believe there are not so many UK UCITS or old UK UCITS willing to continue to be sold in the EU had to apply for the national private placement regime. Obviously, we are covering today UCITS, but what about these other type of funds which are not UCITS coming from the EU willing to be sold in the UK? Any kind of expectation that some similar regime could apply? Is there anything we can provide to the audience on that topic, also beyond the UCITS sphere?
Of course. So the UK government's next area of focus to bring funds into the overseas fund regime and grant equivalents are the money market funds. And then thereafter, we're not quite sure what the direction of travel is. Of course, European AIFs continue to come in under our national private placement regime, which Alexandra touched on earlier, but we're not sure that there are any plans to extend the overseas fund regime to those types of funds, at least at this stage. So really the only other type of funds that are likely to benefit from the retail marketing approval of the overseas fund regimes at this stage are the money market funds.
Okay, so very limited scope so far, if I understand correctly. So Emma, I would like to thank you very much for your insightful contribution to this panel on the OFR regime. So transiting to other topic, because we wanted to give a little bit of flavor as to the latest development in terms of distribution. Obviously, there are a lot of talks about the trends in the distribution and more particularly about the challenges and opportunities that the deployment of artificial intelligence could bring to the distribution or to the recent evolution in that space. So Pierre-Yves, do you want to comment on that one?
Thank you very much, Florence. Yeah, I think we see more and more that clients are willing to use artificial intelligence and that they are, let's say, looking at how they can use the data that they have actually in on their files and how they can actually use it to expand the distribution network that they can have. And we can say, I think, at this stage that artificial intelligence will definitely change how funds are distributed, and yeah, that this will impact actually how the firms and the market, how they see and how they are able to target actually a specific sector in the distribution or a specific type of investors in view of enhancing the distribution afterwards. And there are also tools, because when we talk about artificial intelligence, it's very, very broad actually. There will be also, and there are already, some tools that will enable the investors to, let's say, select the product that they want to have. And for example, we can think about chatbots that will be able to somehow advise the clients on what will be the best product suited for the needs. So I think that the next changes will be actually quite interesting to see and to observe.
A lot of talks, some more concrete experience, and we also see the regulator at EU level and more particularly at local level in Luxembourg taking some position, even I would say promoting the use of artificial intelligence, easing to some extent the onboarding. So do you want to comment on the recent development in that space?
Yeah, sure. I think that the CSSF is very keen to see how the market is actually now using that kind of tool. And they launched actually very recently, because it was last Wednesday, with the Banque Centrale de Luxembourg, a survey to understand the level of adoption of the artificial intelligence and machine learning. And here, I think that the CSSF is really keen to understand how artificial intelligence is used. And one thing that is actually quite interesting is that the CSSF, it's not the first time that the CSSF does that kind of survey, but this time they included the investment fund managers. And I think that it shows that we are not only, the finance center here in Luxembourg is very broad, and we can talk about banks and PSF, but it's not only them, it's also investment fund manager, and under the investment fund manager we have also the distribution function. So then it's also the question how in that particular, let's say, subject, how artificial intelligence is used. And we have also, and the CSSF actually has looked at those questions for quite a while now, because already in 2018 they issued a white paper where they, let's say, set out some risks and the recommendations to tackle those risks. And I think in the Annex 3 of the document is very interesting to see what are those recommendations from the CSSF, because there are a lot of risks that are coming on top of the one that we already know. And the next question is, how do we address those risks? How can we manage them? How will we be able to, let's say, just
take
use
benefits.
And take benefits from the tools?
Okay, thank you very much. You mentioned investment management, and I believe this is probably in the space where we hear more speaking about artificial intelligence. But what would be your view, or what would be the trend in terms of distribution? Because obviously one area is that willingness to be appealing for other type of investors. So is it worth tokenization, or this type of change of technology could ease distribution?
I think, yes. I think that we are now in a new area. It's a kind of a big word to say new area, but what I want to say here is that we have a new generation of investors that is coming, and we need to take that into account. And this is actually particularly important, because the new generations that will come to the market, and that are actually now already in the market and that will continue to come, will not have the same, let's say, they will be in need of investing. I don't think that they will be able to, let's say, rely on the first pillar for the pension, for example. And this is now a need that that we need to address collectively, let's say, to understand that those new generations are also more digital focused. And that's, I mean, it's no big news, but it's very important at the end of the day to see how we can address that. And tokenization, digitalization, tokenization is one of the solutions to address those points and to be sure that we can, let's say, incentivize those type of new investors. So yeah, I think it's really important to have that in mind and to see that as a new solution or as a solution that's complementary to the one that we already have, but that will ease at the end of the day the participation of this new generation into the finance markets.
Concretely speaking, when we were preparing this discussion, you made reference to some concrete example of TA having proposed some innovative solution. Do you want to give a few words on that one?
Yeah, we can. Well, we have already. Well, let's say I think that it's important to say that it is possible in Luxembourg to have tokenized fund shares, for example. And well, although there are no real clear reference into a specific law, we think, and we are not the only one here at Arendt, to think that it is possible, and we have already seen TA that have, let's say, already tokenized shares based on the 1915 law on business companies. But I think that, and also we have also examples of transfer agents that have been, let's say, authorized by the CSSF to do that process. So we can also, in terms of structuring, see that we have many structures or type of structures that are, let's say, emerging. Some of them are considering fully tokenized funds, so all shares are tokenized. In other cases, we see that only partial part of the shares that are distributed are tokenized. And so it's not fixed in stone. I think that we will see a lot of more developments in that context, and that will more and more be not only a trend or something that nobody exactly know what it is, but something that it is, let's say, or that will be used in the future.
An ongoing moving target. And
exactly.
This is the reason why we feel necessary to go into further details on the topic. And with your colleagues within our expert group, you are organizing a specific session there too that we will be mentioning somewhere after summer. So that will be the occasion to enter into more concrete examples and to tease a little bit more than we did today. So we are slowly but surely reaching the end of our webinar. Obviously, since this is dedicated to developments in terms of distribution, we of course had to cover some other developments. To start with, obviously, the EU retail investment strategy. Again, this was part of our webinar of last year. Important topic, and I have to say that since then we are probably happy to see that it has evolved in the good direction. Since there was a question to potentially apply benchmarking to funds, benchmarking which were relatively narrowed because only focusing on cost and charges and performance. And now, based on recent adoption of a final text at the Parliament level, EU Parliament level and Council level, we can say that on one hand we will probably avoid the benchmarking, but merely go in the direction of a peer grouping assessment, which is certainly something which was requested by the market. Obviously, benchmark will still be elaborated by the EU regulators, but this benchmark would be considered as regulatory or supervisory tools for the supervisors to be used and to ensure comparability, I would say. On the second topic, which was of a concern in the context of distribution and still in the retail investment strategy context, there was an expectation or a threat of a total ban of inducement, including for the execution-only platform without advice. And here also it seems that on the basis of the text as endorsed by the two EU authorities, it is also going in the good direction with no such a ban, so meaning that UCITS fund, for example, would still be allowed to be sold on an execution-only basis, even if there was no advice, and still with the possibility to apply some retrocession, which has been identified as a way to still finance the distribution network. Obviously, this might be conditioned by other rules in terms of best interest of clients, test, but again, this is going in the good direction. We expect that on that basis, a trilogue will start, and that we could end up by having a final text somewhere in 2025, and I'm sure that in our 2025 series of webinar, we will pay attention to cover the development in that space. Another area where we can see some evolution is obviously the review and the review of the AFMD2 and UCITS 6 directive, where again, as part of the changes which are brought, there is that rule which has been included, which seems at first sight to be an additional flexibility, and the fact that distributor, being MiFID firm or insurance companies, being selling in financial products on their own behalf, would not be considered as delegate. What does it mean? Still to be discussed and assessed because the text is relatively vague. This is now, since the directive, the final text of the directive have been voted, this is now to the local legislator to implement this text in the national laws. In Luxembourg, the discussion have started within some working groups, and we hope to land up with something which would be flexible in terms of interpretation, avoiding duplication in terms of content oversight, and also reporting probably. Last but not least, I would say that to be complete, we also wanted to draw your attention to the fact that the notification forms, which are used mainly by your team, Alexandra, be it for the notification of passporting, are expected to be reviewed, and we understand that they should be available somewhere mid of July. Yeah, so for everyone who is intending to do registration, there might be some additional information to be included in the notification forms. So these were the topics we wanted to cover today as a matter of legal and regulatory update in the pace of distribution. There might be much more to cover, and we will have other webinars on the topic. I would like to thank you again, Emma, for your insightful contribution. Thank you, Alexandra. Thank you, Pierre-Yves. Thank you to all of you for having been assisting to our webinar. Again, all the questions we have received would be answered afterwards. We will revert to each and every question having received, and we will also send you the recording of this webinar. And please stay tuned, since this is a series, as mentioned. We have a few webinars before summer and a few other after, and you see that we have 5 interesting ones coming after the summer. Precise dates will be released very soon, and we hope to see you all on one of all of these webinars very soon. Thank you very much for your presence and attention. Thank you.